Now, I am not telling you those are the nails that he stumbled against, he hit his flip-flop against. I'm not telling you that. In fact, I'm telling you the opposite. They are not. They're at a different part on the deck. But I offer them to you so that you can see this can happen. These nails can pop. The photo from the prosecution, from the police, wasn't clear enough to show you the area where he stumbled and fell. But you know this can happen. So he goes outside, and he sees Mr. Bain, and he sees the two SUVs. And you hear from the prosecution witnesses what I'll call changed evidence and fake evidence. You heard some proof about the alcohol and marijuana. That is not offered to suggest in any way that any of these, and I'll use a combining term, any of these kids in the vehicles, because that's what they are, they're kids. Any of these kids in the vehicles to suggest in any way that it was their fault for getting lost. It wasn't. If any one of them is blaming themselves, they should stop now, because this wasn't their fault. It's not offered to show that. It is offered to show you that maybe their recollection of events isn't as clear as it might ordinarily have been. And it's not disturbing that their versions differ from one another, don't completely mesh. That's to be expected, because up until that memorable event on the driveway, there was nothing memorable about their trip. It was one of a million. Why wouldn't it? Why would it be memorable? I'm guessing you don't remember the details of your trip here today. Why would you? It's not memorable. So it's not disturbing that their details don't mesh. But it is disturbing that they are willing to change their stories to fit the prosecution narrative. As an example, Ms. Nadolski, she told you, I saw two SUVs and a motorcycle, and I made note of that because that was unusual. But that's not what she told the police. What she told the police was not two SUVs and a motorcycle, but two motorcycles and an SUV. And lest you think she was confused, she wrote it down on her Post-it notes. She wrote it down twice. She wasn't mistaken. She changed her testimony to fit the prosecution narrative. Mr. Walsh told you when he testified on direct that they came up the driveway, they started their three-point turn. They were actually in the second leg of it when the lights come on and he hears the shot. But that's not what he told the police. What he told the police was the two vehicles were stationary down by the telephone pole when the lights come on. Mr. Bain is down there with him. And then he hears the shot. But he changed his testimony to fit the prosecution narrative. Mr. Bain himself told you that he didn't go roaring up that driveway 10 to 15 miles an hour. But then on cross-examination, he said, I was in third gear. And to be in third gear, you have to be going at least 25 miles an hour, maybe as much as 60. If he was going less than that 25, he would have stalled out going up the driveway. But he didn't. And he only stalled out at the top because he ran out of time and he ran out of driveway. And he couldn't downshift without stalling. But he changed his testimony fit the prosecution narrative. And Ms. Whiting, she told you on direct that the man on the deck, Mr. Monahan, we know that now, that the man on the deck held the gun kind of horizontal out toward our cars. That's not what she told the police within hours of this happening. She said the man on the deck fired a shot into the air. And I pressed her a little on cross-examination. I said to her, that's not what you told the police, is it? No, it isn't. I said to her, you told the police he fired a shot in the air, right? Yes, I did. And the reason you told the police that was because that's what really happened, right? Yeah, that's what really happened. He fired a shot in the air. But she changed her testimony to fit the prosecution narrative. Now, why is that important? Remember in the beginning, Mr. Morris told you that he would show recklessness and depravity. And the way he would do it was by showing that Mr. Monahan fired 2 shots at those vehicles. But Alex Whiting's testimony, what really happened was he fired in the air, eviscerates that. And she changed her testimony to fit the prosecution narrative. That's the changed evidence. Let's talk about the fake evidence. I'm going to lump 3 of them together. The fingerprints, the DNA, the gunshot residue. Fingerprints. Trooper Gabler got on the stand and told you about that. And a word about Trooper Gabler. He is not an expert. Mr. Morris has agreed and the judge has ordered. He's not an expert. He's just some guy. He knows no more about fingerprints than you or I do. He is not an expert in fingerprints. And what he told you was, I looked at the gun, I looked for 2 kinds of prints. Patent prints and latent prints. Patent prints, we all know, if you have a glass tabletop or a window or a cell phone screen, you touch it, you can see the fingerprint. It's obvious. It's patent. He didn't see any of those. No surprise. This isn't glass. This is wood. It's porous. No surprise. He looked for latent patent fingerprints. Those are the kind you have to develop with that special bichromatic powder that he told you about. And he dusted and he told you, I didn't find any latent fingerprints either. Not so fast. Remember I showed him the photo. This is photo 994. I don't know how well it comes out on here. I'll try to blow it up for you. Remember I said, Trooper, you see all those black smudgy marks? That's from the oils from fingerprints, right? Well, he couldn't say that they were for fingerprints. Wrong button. He couldn't say that they were for fingerprints. But he did say they were from the oils that you typically leave with a fingerprint. So it's not that there were no fingerprints there. It's just that there were no fingerprints of evidentiary value. Well, big surprise. You touch a piece of wood, if you press, it might leave one. But if you swirl or slide or swipe, you're not going to find a patent fingerprint. You're going to find the oils, which his bichromatic powder revealed. But I think the implication you're supposed to draw is Kevin knew he was in hot water, and so he wiped off the gun, but just did a lousy job at it because he smeared the prints but didn't remove the oils that would evidence the prints. It's not that there were no fingerprints there. It's that there were no fingerprints of evidentiary value. Let's talk about the DNA. Ms. Caruso got on the stand and she told you about that. And remember her chart, 24 different loci, and you had to match them. And she checked 5 samples, 4 from the gun, 1 from the shell that they found in the bedroom. Big surprise. And as to the other 3, she said, no match. Not so fast. We looked at her chart, 24 spots. And I asked her, how many spots do you need? How many loci do you need for a match? And she said, well, with a mixed sample like this, I need 12 before I can declare a match. I need 12. And I asked her, well, all you can say really, not that there's no genetic material at all, but that there just aren't 12 for you to see, right? Yes. 3 of the 4, that's what she said. And I suppose the implication is supposed to be that with surgical precision, Mr. Monahan removed at least 13, in at least 13 loci, he removed the genetic material. So she was frustrated and couldn't declare a match. Now I asked her, are there ways to chemically remove it, like bleach or peroxide? Yes. Did you find evidence of bleach or peroxide? No. Did you look for it? No. Did you ask for a better sample from those 3 spots? No. Could you have? Yes. Did you ask to get your own samples? No. Could you have? Yes. Again, the implication is that he destroyed enough genetic material where she just couldn't say there were 12. Maybe 2, maybe 11, maybe 6, maybe 9. You don't know. She didn't testify about that. And then, something very curious happened. As we stood at the bench discussing, Ms. Caruso blurts out, all of my testimony is wrong. Because you don't need 12, you actually need 8. I was wrong, my testimony is wrong, that's their DNA expert. Just because she's offering expert testimony doesn't mean you have to accept her as an expert. Doesn't mean you have to accept her conclusions. You decide what the facts are. You're the sole judges of the facts. You can disregard her testimony just like anybody else's testimony. Finally, the gunshot residue. The information that you had was from Ms. O'Connor, where she said, I checked the gun, I checked the bore, there was no gunshot residue. And the implication you're supposed to draw is he somehow removed it. But there was no testimony about that. And you know what else was missing? Ms. O'Connor never said there was no gunshot residue and there should have been. There should have been gunshot residue, and because it's not there, that tells me someone removed it. All she said was, I didn't find any. the last one, the wadding and the shell casing. We heard from a couple witnesses about the search for the wadding. I could be wrong on the name. I think it was Investigator Spezio. But one of the witnesses said, we checked a 30 by 20 area, 600 square feet. Couldn't find the wadding. Now, he acknowledged shotgun wadding will travel a certain amount of distance when you fire the gun. He doesn't know how far. 150 feet? I don't know. 100 feet? I don't know. 50 feet? I don't know. But he was sure it could. And so he looked in 600 square feet. Couldn't find it. And then Trooper Gabler told us not 600 square feet, 60,000 square feet. An acre and a third they searched, looking for wadding. Now, we don't have a precise measurement how big this is. We have the diameter of a nickel or a dime from, I think, Spezio. And a shotgun shell, what is it, about 3 inches? Well, part of that is the shot, and part of that is the powder. So it's obviously less than 3 inches. And in 60,000 square feet, they couldn't find it. Now remember what Trooper Gabler told you. It comes in all sorts of colors. Red, brown, white, yellow, green. They're searching a green field, 60,000 square feet, and they can't find it. And the inference you're supposed to draw is that when they have 6 or 7 or 8 guys right next to each other, walking a grid pattern in a line, they can't find it. But somehow, in the middle of the night, in the dark, this man sneaks out, steals out into the grounds, finds 2 shotgun waddings, hides them, conceals them, or destroys them. That's what you're supposed to believe. Here's the problem with that. They told you there is no evidence. They had no information whatsoever that anyone went outside the Monahan residence from the time of the 911 call until the time law enforcement arrived. Nobody went outside. What does that leave? That leaves the time from the second shot to the 911 call. And there's no evidence that anybody went out that time either. Now, we do have the stipulation of the parties. We stipulated that had she been called, Tara Smith would have said she could see small lights moving around at the residence. Not outside, at the residence. There is no proof whatsoever that Mr. Monahan, or even Jinx Monahan, went outside and grabbed that wadding in that 60,000 square foot area in the dark without lights. Isn't it more likely that either A, the police did a lousy job looking for it, or B, probably more likely, they just couldn't find it because they're looking in 60,000 square feet? Isn't that more likely? And then there's the shell casing, and this is the strangest twist of all. We heard that when you fire and then you rack to load a new round, that the first shell ejects out of the gun, and it can travel a certain distance. Nobody was clear how far that would be, but they were clear that it can travel, and that if it lands the right way, it can bounce and travel even farther. And you're supposed to believe that when Mr. Monahan fires that warning shot in the air and then racks the gun to load a new round and eject that shell and then stumbles, his flip-flop hitting the nail, and the gun goes off, you're supposed to believe that after all that was done, he knew he was in hot water, he comes outside, gets that one shell, alters, conceals, or destroys it, and then when he's up in his bedroom, takes out the second shell and puts it on his dresser. Now, we know now that it was that second shell that hurt Kayla. Why would he save that? If his intent was to destroy, alter, or conceal evidence, a shotgun shell, and I suppose the wadding, why would he save that one and leave it on his dresser, right next to his bed, right next to the gun that fired it? It makes no sense. And one more thing, it reminds me when I say fires the shot in the air and then stumbles and the gun goes off. Remember Ms. O'Connor's drop test? She said she wasn't sure about the safety, so she scrapped the whole test and redid it. Was there anybody who told you at any point that after the shot in the air, he put the safety on and then came over here and stumbled and thumped that gun and it went off? Of course he didn't. It wouldn't make any sense. Because from his perspective, the threat level is still rising. Because those vehicles, once stationary, came back up, came up the driveway, closer and closer and closer, and nestled in right underneath his deck. Changed evidence and fake evidence. Now, I don't know. The way our system works, when I sit down, I'm done. I don't get to get back up and respond to what Mr. Morris says. So I don't know if he's going to play the 911 call, so I'll address it now. In a word, it was heartbreaking. It was gut-wrenching. Anybody who is not moved by that call has a heart of stone. But as emotional as it was, it doesn't fill in the holes in their case. It doesn't change the mindset that Kevin Monahan had that night. There are many things that we know now that he didn't know then. We know now that they were teenagers and not a group of marauders. But he didn't know that. He looks down the driveway and he sees two SUVs, and how many people could be in there? Maybe 10. And he just doesn't know. And we know now that they just drove up the wrong driveway. But he doesn't know that because they're not acting like lost people. And we know now that they were looking for a party and not a house to break into. But he didn't know that. In the words of Jinx, we thought we were being invaded. He didn't know. And maybe you will think that it was dumb for him to go outside instead of calling 911. And maybe it was. And maybe you will think it was dumb for him to go outside with a loaded shotgun. And maybe it was. And maybe you will think it was dumb for him to be walking along that rail with a gun that can go off when no one pulls the trigger. And maybe it was. But we have a word for that. That word is not depraved. That word is not reckless. That word is negligent. Doing something that a reasonably prudent person wouldn't do. Or not doing something that a reasonably prudent person would do. Not depraved. Not that evil, wicked, blackened heart. not reckless, failing to or appreciating a risk and disregarding it, simply not caring. Negligent, dumb. You know he didn't do this on purpose. He's not accused of intentionally killing this girl. You know he didn't shoot her on purpose. He's not accused of that. He's accused of acting with an evil, wicked, blackened heart, an utter disregard for the value of life, wantonly. And recklessly. Not of killing her on purpose. We have a word for what he is. Negligent. When you get the verdict sheet, you will see that there are some new charges. You came in here with 3. Murder, reckless endangerment in the first degree, tampering with evidence. There are 2 new charges for you to consider in the alternative. In the alternative to murder, you can consider manslaughter. In the alternative to reckless endangerment in the first degree, you can consider reckless endangerment in the second degree. And then, of course, there's the tampering charge. We'll set that aside. I know it's football season. I'm a baseball fan. I'm a Red Sox fan. And when the Red Sox star slugger, Rafael Devers, goes up to the plate, if he goes 4 for 5, or 3 for 5, even 2 for 5, he's had a good night at the plate. Kevin's not here to go 2 for 5, or 3, or even 4. He's here to go 5 for 5. When he pled not guilty, he said, I'm not guilty of all of this. I may be negligent. I may be dumb. But I don't have that evil, wicked, blackened heart. And I wasn't reckless. I was dumb. So, the question will be for you. Ask yourselves. Ask each other. If he really wanted, if he really had this evil, wicked heart, this black heart, why not kill Rory Bain when he's 20 feet away? If he really has this evil, wicked, blackened heart, why not fire at those 2 SUVs that are right down in the driveway when they're stationary? If he really has this evil, wicked, blackened heart, why not shoot at the SUVs when they come up and they back up to do that 3-point turn and they're nestled right underneath the rail, right underneath his deck, 15, 20 feet away? They're sitting ducks. Why not fire and fire again and fire a 3rd time and reload? If he really has this evil, wicked, blackened heart. Why fire a warning shot in the air at all? If he has this evil, wicked, blackened heart. Why wait until they're leaving, which is what he wanted in the first place? Why wait until they're leaving to then shoot at a moving target that's getting farther and farther and farther away? It doesn't make any sense. It doesn't make any sense unless the answer is because he didn't want to shoot anyone. He didn't. Because this gun will fire when no one pulls the trigger. Just like it did at the state police lab, as Ms. O'Connor told you. So, proof beyond a reasonable doubt. What does that mean? The judge is going to give you the law. He doesn't need my help. But I will say this. It's the kind of doubt that people would have in matters of this importance. What's a matter of this importance? How sure do you have to be that your retirement is safe at the bank? How sure do you have to be the brakes in your car work? How sure do you have to be about the people who are watching your kids? Isn't it at least as important as those things? How sure do you have to be? How sure do you have to be that that gun won't shoot a hole in the ceiling or down through the floor if Officer Canale dropped it? Think of reasonable doubt. Sorry, think of proof beyond a reasonable doubt as a frozen lake. Think of all the things we brought you. Changed evidence, fake evidence, a gun that will shoot when no one pulls the trigger, and whether it makes any sense that he would fire at a vehicle that was leaving, which is what he wanted. Think of all those things as cracks in that frozen ice. Would you walk on that ice? Would you let your kids? I suggest to you, if the answer to either one of those is no, then you have a reasonable doubt. And if you do, your oath and the law commands that you find him not guilty. I told you in the beginning that when we got here, I would ask you to say two words. Not guilty. Because this was a terrible accident. And you, the jury, have realized that by now. Thank you.
We'll take about a 5-10 minutes break. All rise for the jury exiting. Thank you. We are in recess.